You'll see some people joining the stage with me. These are my partners who have came on very, very eagerly, and certainly we couldn't have done this at all without them. We partner with the law firm of Arendt, Fox, Schiff. It's a high-powered law firm in America, considered to be in the top 10% of law firms in this country. And one of their partners reached out to me as a result of a contact he had with Nate Cummins, who was, you heard from yesterday, who was the city council for Evanston. Arente Fox Schiff, or Lynn Watkins, who's the partner of Arente Fox Schiff, wanted to get involved in the reparations, local reparations movement. And Nick turned him on to me, and we had been working on slavery disclosure ordinance for about 15 years, and to no success. And so when we had an opportunity to bring in a law firm of this magnitude, that was the first thing that we wanted to address. And so they agreed, and what we wanted to do was take the slavery disclosure ordinances that had been on the books and strengthen it and get it enforced, and then utilize it as a means to prop up the local reparations movement. So joining Lynn is Stella Oyalabu, and there's one other partner with Arente Fox, Jeff Kennedy, who's not here, who worked on this process. Also joining me as a partner is Professor Britta Redwood. Thank you. Professor Britta Redwood is a professor of law at Howard University School of Law and head of the Movement Law Clinic. And with her are two students, Pablo Vasquez and Melody Williams, who are working also in the Movement Law Clinic, who are also partners. We didn't know that they were working on slavery disclosure ordinance until a little later. Someone who's not here introduced us. And Brother Justin back there, Thurgood Marshall, Civil Rights Law Center at Howard University, also partnered with us as well with the African American Redress Center. And his colleague just walked in as well. And so we had two different legislations that we were working on at the same time, unbeknownst to either of us. And so when we got together, it was suggested that we just combine our work into just one legislation that we can use around the country. And I thought that was a great suggestion, and everyone was really excited about doing that. So we put these two great teams together and came up with this model legislation. Before I begin, I want to just comment a little bit on Dr. Tillery's message. He gave us an academic foundation for what I presented yesterday. We have the power to make this happen. There's a total dependency on the black vote for 2020, 2024, and we must utilize the data in that report as we make this demand, and we can make this demand. And those three foundational truths, again, is that the Democratic Party needs the black vote. He says 86%, if they lose 2%, is over, and they're at around 68%. So there's no question that they need our vote. The second foundational truth is that we need something right now from the Democratic Party, a commitment to reparatory justice and ending racism and systemic racism in this country. And the only way to accomplish both of those at this time is an executive order. Those are three foundational truths. And I think everyone here must leave with that, and also leave with the understanding that you are the ones who are going to have to take that message in your community and lift that up if we're going to win. And as he also stated, if we don't do this now, who knows what this country is going to look like going forward. That's how dire it is. But we have the power. And I want everybody to know we have the power. If it doesn't happen, it's because we didn't do all we could to make it happen. And I take that as, you know, a responsibility that we come into these spaces and we lift up the ancestors And we're saying we're standing on the shoulders of those who walked before us. We are birthed for this particular moment. We cannot lose sight of that. It's us right now. I want you to make sure that you go into the resource room and get these postcards. There's still too many postcards on those tables. It's only 2,500. I was at a conference, we had 5,000, and they all left with the exception of about 400. I only brought 2,500 to this conference, and they're still on the table. They should not still be on the table. Take these postcards and make sure that they get out next week. Also, you have this document again, and Quandra, can you stand up? Where you at? Okay, Quandra is my assistant with Reparations United. This is a QR code where you can fill out the form to join the EarnTheBlackVote.net campaign, national campaign. And so you want to make sure, and she'll be circulating that around the room, and you want to make sure that you don't have to do it now, Quandra, but just make sure that you fill out that form and join one of these working groups, and so you can be advised of what's going on and actually take part in the work. So this workshop is entitled, I'll put my glasses on. Thank you. So I already know, right? If I can get this together. Developing, utilizing, implementing, and defending slavery disclosures and redress ordinances. Oh, it's right there. This is something what I want to talk about today. Why is slavery disclosure and redress ordinance? What mechanisms can we use? What is a slavery disclosure and slavery disclosure ordinance? Some history of slavery disclosure ordinances. What were the intended outcomes and the key components? And then we'll go into the workshop with our team here, lifting up the model slavery disclosure and redress ordinance that they collectively worked on for all of us in the movement. So why the slavery disclosure and redress ordinance? Right now, all of the attention and energy in the country, most of the attention and energy in this country is around governments, bringing governments to the table for redress. However, there are also other, what I call non-governmental complicit actors, corporations, institutions, and individuals, families, and we've kind of gotten away from them. All the focus is on local, state, and national government and the federal government. In the early 2000s, there was a lot of attention on corporations and institutions. In fact, there was several lawsuits that was found, and they were all filed, and they were consolidated in one lawsuit in 2002, and then it was heard in 2005. And after that non-successful lawsuit, a lot of attention was taken away from slavery disclosure ordinances. But these are some of the companies and corporations: CSX Railroad, Union Pacific, all these banks, Citibank and Wells Fargo, et cetera. Norfolk Southern was a railroad. We did an action against them in 2016 in Chicago, where the reporter said we forced a string of concessions. We didn't get the dollars that we wanted, but there was many concessions that they did have to attend to. We utilized the slavery disclosure ordinance that was on the books in Chicago for that purpose. Harvard University, Johns Hopkins School of Medicine, Brown University, the Vatican. As you heard, we went to the Vatican and presented a presentment to them. And then family foundations, the McCormick family here in Chicago, Pritzker family here in Chicago, in Illinois. And there's other families that you'll find in your states and your cities who have ties to, or were complicit in the harms against our ancestors. So what mechanisms can we use for these non-governmental complicit actors? Again, I was talking about the lawsuits. There was a lawsuit in Tulsa just recently. The Black Muskogee Creek Nation won a lawsuit. Reparations presentments was something we can use. That's something that we submitted to the Vatican. It laid out the crimes and offenses that were committed. It laid out the continued impact of those crimes and offenses. Then it laid out what we wanted as repair for those crimes and offenses. And that's the basis of a presentment. It's a official document declaring what is owed by a institution or corporation or whatever. Also, we can use direct action, nonviolent civil disobedience, picketing, and boycotting goods and services from these corporations. And we can also use the Slavery Disclosure and Redress Ordinance for a way to address these particular actors. And here we use the government to assist us, whether it's the state government, the local government, and even the federal government. Congresswoman Maxine Waters sent a letter to about 11 insurance and banking corporations last year as chair of the House Finance Committee, House Finance Committee, telling them that they need to disclose. And so we see this happening on every level, but again, we have to get these implemented, and this is why we work with this team to present, this particular legislation. So I talked a lot about slavery disclosure, but I haven't really defined what it is. So slavery disclosure is a state, county, or municipal law, statute, ordinance, or resolution that has a purpose that requires slavery-era entities to disclose their enslavement actions. If they want a contract with the city, if they want to do business with the state, that if, when they send their RFP in, their proposal for whatever bid that's out there, they would have to research their records and determine if there has some complicity, and if so, they had to disclose it. Some of the disclosures require them to identify the enslaved persons by name, identify the profits, and document the extent of the complicity. So it identifies offending parties, and it requires an administrative body to inform the public. That's major importance, that they must inform the public of these findings, because one of the things is, they felt when they first introduced this, that if we knew these people had ties to enslavement, we wouldn't be doing business with them as black people. And the fact that they're hiding that is commercial fraud, right? Because they're suggesting that they're someone that they're not, or they're hiding some behavior that is detrimental to the consumer if that consumer found that knowledge. And so there's been fraud cases brought up against these corporations as well. And that there had to be an annual report to the city, and then they had to offer some engagement in community repair. Now, these are existing cities and states where actually they have slave disclosure ordinance already on the books. And many of us in the movement have never heard of this. Massachusetts was the first government entity. State Senator Bill Owens of Massachusetts was the first entity to introduce the slavery disclosure ordinance. Chicago was the first city, and you can see these other cities. The problem is that these ordinances are not being enforced, even though they exist. And that's why I've been working on this for like 15 years, trying to get these people to enforce this ordinance in the city of Chicago, which it was the first city. And so, what was the, okay, I'm out of order. So, challenges and opportunities. I don't have that here, but challenges and opportunities. What are some of the challenges we have? There's been lack of enforcement, as I talked about, lack of mandate for redress in the bills. Los Angeles had the strongest legislation that didn't require, but offered the corporation to voluntarily contribute into a fund for redress. That was the only legislation that had actual redress in their legislation. And to date, I think that passed in 2005, and to date, there's not been a single corporation that has voluntarily submitted any type of redress. So that's the challenge. Of course, as you heard from Professor Tillery, and you hear from the lawyers here today, that defending these is a challenge. Legally defending them will be a challenge. It's a challenge to amend some of the existing ordinances. I think that's also an opportunity, as well as introducing new slavery disclosure ordinances is a challenge, but also an opportunity. And okay, I'm gonna skip that because I've already talked about that. Thank you, brother. Appreciate that. So, what are the key components and sections of a slavery disclosure ordinance? This is what we found in all of the slavery disclosure ordinances that exist today. There's purpose and findings of the ordinance, definitions, disclosure requirements, redress requirements, compliance mandate, enforcement mechanisms, and administrative structure. Now, not all of the slavery disclosures that I showed have all these components. In fact, some of them only have one or two of these two or three of these components. And some have all seven, like in the case of Los Angeles that has a redress requirement, but it's voluntarily. So now I want to get into the model slavery disclosure ordinance and redress ordinance. How many of you got it in the WOVA app? All right. How many of you got it in hard copy today, or since you've been here? Who does not have it? All right, Quandra, if you can just keep your hands up, and she'll make sure you get one a hard copy. It's important that we have these important that we have a copy, because this is a additional means for funding our repair at the local level. We know that the city budgets are limited. We didn't give a report from in the Midwest for Chicago. Chicago just passed, just passed their budget for 2024, and we got $500,000 devoted to a commission and $5 million devoted to an Office of Returning Citizens, and we were advocating for $23 million, and part of that $23 million was a repair to basic income program for returning citizens. So that $5 million, part of that would go toward returning citizens for repair to basic income. But these are areas where the slavery disclosure, utilizing this method, is a way to get additional resources in our spaces to do the repair we need to do. Because everybody's talking about how do we fund, what, and the funding is limited on the local level. So again, our partners are Aaron Fox Schiff Law Firm and Howard University School of Law and Movement Law Clinic. So the key differences to this model, slavery disclosure and redress ordinance, than those that were in the past is that it mandates greater disclosure, and we'll talk about that. It details what those compliance measures should be. It has a mandatory redress component, and it allows for civil enforcement. Remember I said that none of these initiatives have been enforced around the country, so this allows for civil enforcement. And so I'm going to go through this we're going to go through this legislation together now, and hopefully, we can get some discussion on parts of it. So the title of this legislation, and we have it here where you can insert your municipality, your state, your governing bodies, and so when you introduce it, and Professor Redwood, when she talks, she'll talk about how we can assist you in that process. So the title shall be known officially as the whatever city enslavement area disclosure and redress ordinance. And it has several definitions. And again, many of the ordinances did not have definitions. Definitions are key because we want to be all speaking the same language. We don't want anybody confused or anything ambiguous about who we are talking to and what is required. And so we talk about, and I'm not going to go through all of these, awarding authority means the component or entity or person that has the authority to enter into a contract or an agreement. The company is any person, firm, corporation, partnership, or other business entity, or a combination of these. So we want to be clear when we use that they know who we're talking about. Contract means any agreement, franchise, lease, or concession, including an agreement to any occasional, professional, technical, personal services. Which is let, awarded, or entered into on behalf of the state or city. So that's the contract. And it has a lot of different methods in which you can define the contract, or those who are entering into the contract. And the contractors means anybody who's entered in the contract. Descendant is an important definition. It means any living individual can trace their lineage or ancestry directly or indirectly to an enslaved person or persons. This includes, but is not limited to, children, grandchildren, great-grandchildren, subsequent generations, whether through biological or adoptive relationships, as well as individuals with verifiable genealogical evidence or documentation that establish a connection to an enslaved person. This term descendant is intended to encompass a broad range of familial connections. We don't want to limit who we're talking about when we're talking about descendant. Enslavement era. This is key because you have enslavement era and you have the slave trade. And those are two distinct periods and two distinct levels of crime and atrocities and actions. So we want to be clear because some corporations were only involved in the slave trade, the shipping, transport, sale of Africans, and some were involved in the actual enslavement process of leasing and enslaving and of stealing labor from our ancestors. So those definitions are pretty important. Enslaved persons mean any person living in the United States or territories that preceded its establishment, which became part of the United States. That's important because you have some scholars saying that we shouldn't start the process until 1777 or 1787, when the United States ratified its Constitution. That's the period from which we should begin. And there's a significant scholars pushing that. But if you understand the concept of predecessor corporation, that these 13 colonies were actually corporate entities that became the United States. So these were the predecessor governments that became the United States. So we don't, and also, so you can't leave them out. And also, what's important in defending that is that the United States, through their House of Representative apology and Senate apology, has already confessed to 1619. So we don't want to, if you already confessed to this, why would we limit it? So it's important that we know from the date in which we're starting. So I'm not going to go over any other of these definitions, but make sure that you're aware that there's participation in slave holding and participation in the slave trade. And with that, I'm going to ask, is there any questions so far, comments that you want to make around understanding the Slavery Disclosure Ordinance in general, or anything related to the definitions that we raised? My sister? Yeah, you can project. Mm-hmm. If these, so you mean it's been introduced already? Yes. Okay, or it's already existing? Well, it's been introduced. Okay. In that municipal or state administrative department to hold it, but it's not enforced currently in the country. How do we hold that? How do we hold that entity accountable? Okay, so I'll talk about those other areas of holding them accountable if you don't use the Slavery Disclosure Ordinance. You're not going to be able to hold them accountable until you actually have this in place in law. That's when you can be able to enforce it from this perspective. I see you picked up the mic, Len. Did you want to?
Yeah, I was just going to say that the ordinance contemplates that would most likely run through a procurement department. So whatever department would be responsible for letting public contracts in your state or city. So that would presumably be the designated administrative authority at the time that the ordinance or the law is adopted.
Yeah. Yeah, you have to have it introduced, adopted, and put in place before you can actually utilize it.
Just one, can you hear me? Hi.
Hi, my sister.
Just, I'm really interested in the descendants piece of the
Definition.
definition.
Okay.
And this feeds into a part of the conversation that's happening around who's due and owed reparations. And I just wanted to make an introduction and maybe ask for it to be addressed. If we're looking at corporations, and we're looking at corporations that were formed before the United States became, one of the things we know for sure is that they were international in their business scope.
Exactly.
And in the trafficking of Africans to be enslaved, they trafficked throughout the so-called New World, right? So one very clear example is Brown University, that was founded by the Brown brothers, who were some of the most prolific enslavers and had plantations throughout the Caribbean.
That's right.
And so if we're going to speak about descendants, I, as a Caribbean native, born in the Caribbean, and others of us would actually be able to, trace or whatever through that. And I just want to introduce the notion that as you look through corporate complicity for enslavement, it's not only those who were born and served and suffered in the United States.
Right.
It's the entire North, South, Central Americas, the New World.
Sure.
And we need to really hold that in as we think through redress.
That's extremely important, and as a term that defines us all, it's a term called Afro-descendant. It pretty much mean that you had an ancestor somewhere in the Western Hemisphere who was enslaved, and we utilize that to make no distinction. In this particular redress ordinance, it is in regards to crimes committed in America by America, and so during a period of enslavement. So it wouldn't be technically, and there's other legislation that we remove any non-descendant criteria from. But for the Slavery Disclosure and Redress Ordinance, it's specifically tied to enslavement in the United States and persons who can trace the enslavement in the United States. This is a slavery era only redress mechanism. It's not for Jim Crow. It's not for current crimes that are being committed, specifically for slavery era. And Hunter, and this will be the last question, and we're going to go to the other sections. But thank you for that question.
Yes, can you hear me?
Yes, Bob.
Yes, thank you, Kamm, for your informative presentation. I really appreciate it. It brought a lot of clarity to this effort
Did you have a question?
since former Alderman Dorothy Tillman got her ordinance passed, which, of course, you know, nothing hasn't been done. But two quick points. Number one, my group that I'm a part of, the Humanities Summit, which is based in Europe, this ordinance, as you have drafted it, will be very good for them to address countries in Europe, because this is a very good template, and I will pass that on to them. The second thing is, and I'm not a lawyer, I'm a neuroscientist, but so I'm going to address this to y'all. As far as I have read, and I do have a lot of lawyer friends, by the way, slavery is not mentioned in the United States Constitution. Is that correct?
I think it's servitude. Go ahead.
The actual word is not, but in at least three separate provisions within the Constitution, it is
But-
referred to the those in the land of the slave trade, 1808,
Right.
the 3/5 clause, and the
14th Amendment.
fugitive slave act.
But in the Constitution, it's not there. So when we say legally,
Go ahead.
we have to, I'm just suggesting to think that through, you know, particularly with Judge Leon Higginbottom and his 10 precepts of slavery jurisprudence, where he has documented all the laws in all the states, many states, particularly the colonies, where the crimes are listed, right, but they're not attributed to slavery. But it's just something to discussion, so I'll just leave it at that, and we can talk about it
Thank you
later.
so much for that.
Thank you.
Kenneth, did you have a question or? Okay, all right. So I want to bring up Professor Britta Redwood, who's going to talk about the purpose, findings, and compliance.
Certainly. Sorry? I'll stay here. Is that okay? I like to sit down. So I just want to talk through a couple of different pieces of this bill. The first piece, right after the definitions that you see, is a findings and purpose section. Every single legislative body has its own norms and its own ways of doing this. And as you'll know, oh, I'm sorry. So it's right on page 2, section 3, at the bottom of the page, purpose and findings. So this is a model ordinance, and every legislative body has its own norms and its own way of doing things, and there are experts, often at the state level especially, who will refine and revise model language to fit the local requirements. So this is in a way, it's a placeholder, but what it does is it establishes legislative intent. It indicates what the legislature, be it at the municipal level or at the state level, wants to achieve by passing this ordinance. And the importance of this at this particular moment, as Professor Tillery reminded us, is that we know every time we step up to ask for justice, we will be challenged. That's the moment we're living in. And so it's very important to be very clear about what the legislative intent is so that this bill isn't twisted and misrepresented. And so again, when you take this home and you work on this at home, this section will probably change. But the purpose here is to indicate that we have to be very clear about what the legislative intent is. And really the takeaway, the gloss of this section is to insist that the public has a right to this history, right? So we didn't have a transitional justice moment in the United States. Well, we did, but it was very, very short, and it ended, and then it basically got reversed. And transitional justice is so important to understand the world that we live in now. And so this part of the bill says that there's a public interest in getting access to that history and getting it right, and to helping us all understand why we are in the situation that we are today. So that's the purpose and findings section. And I want to get to pick up the question of descendant. So descendant appears in the definition section, and the only section of the bill in which that is referenced is in the purpose and findings section. So we're talking here about how important it is for the descendants of slaves to have this healing process, because being denied our history and access to our history is a dignity harm. But there's nothing in the bill as it stands now that would make descent a qualifying requirement to qualify to sort of get access to whatever monies would come from this. It's going to be, different at the local level. It's going to be hashed out at the local level, but descendant really comes up in the purpose and findings section to talk about the dignity harm that the descendants have suffered. And then compliance. So if you'll come with me, if you have the bill in front of you, to the fourth section, section 4, compliance. What is in this compliance section? I'm going to give you the quick and dirty. So it says that companies that are doing business with the city have to submit an affidavit certifying that they've looked into their history with slavery. Why an affidavit? Why not just a form? An affidavit is a sworn statement. So the stakes are high when you submit an affidavit. You have to tell the truth. Otherwise, you're on the hook, right? So every company has to submit an affidavit, and I think what we've seen, Melody and Pablo have looked into the history of these slavery disclosure bills. We have all of them, so we have a folder with them. We're happy to share that with you if you want to look at them, the ones that have been passed already around the country. And as Kamm was saying, they haven't really been enforced. And you know, our hunch was that companies who don't want to do this, they will very likely just fail to submit an affidavit, right? Because they know the legal, that they're on the hook when they submit an affidavit. And so our colleagues are going to talk about the enforcement piece, but if you don't submit an affidavit, there are consequences for that. So it gets companies on the hook for submitting an affidavit, and it requires that they do so if they don't want to suffer the consequences. And then the other important part of the compliance story here is that the companies have to make available their records, right? So getting that history down, making it available to the public. And then there's a role for an administrator from the city to distill those records, to publish a report that is made available to the public. And then there's a public hearing provision as well. So once this company submits its affidavits, makes these records available, those records are looked at and distilled by a city administrator. And then after that, there's a public hearing, and there's an ability to have the company come to the table and have a sort of public confrontation. And so the purpose of this section is to create a system of checks and balances so that conversations are happening, records are being published, even when people are in the mix who don't necessarily want this to go forward. So thank you. Questions? Yeah.
Got one in the back.
Oh, okay.
I don't know if you want to project from the back.
Hello, good morning. I had a couple of small questions. I'm very intrigued by these ordinances. I'm assuming that the decision not to disclose or even file an affidavit would be one made by a CEO or shareholders for these companies. So in theory, could members of the public question the actors responsible, or could you identify who the decision makers are for making that decision not to disclose and create a process of public questioning of the CEO or of the shareholders at a shareholder meeting, and have those types of avenues been explored?
Yeah, I don't think that we have looked at that angle. I mean, the way that this is structured, it's voluntary in the sense that a company has to decide that they would like to pursue a governmental contract, that would be of benefit to that actor. And in order to participate in the selection process, any entity with a tie to slavery or that participated in the slave trade is required to submit a statement of redress in the affidavit as part of that process. So, you know, conceivably they could make the decision to not participate in the contracting process altogether. But if they participate, this is a requirement. It has to be submitted.
And if they lie, or if they don't submit an affidavit, or if they submit a false affidavit, then there are provisions to go after them at that point. But this is the price of the ticket, is to do business with the city is to comply with the ordinance.
Can you also talk about some of the public reporting in regards to his question, that we really wanted to have a interaction with these corporations in the public space?
Right. So when a company decides that they want to do business with the city, and they go through this process, they submit an affidavit, they find links to slavery, they disclose those links, the city administrator or the state administrator has to publish a report, and then there's a public hearing, as I was mentioning, where the company has to be present to confront the public. This is going to be especially exciting in places where there's a robust reparations commission, because they're going to show up in force, right? And there's going to be, there's going to be press there. And then there are annual requirements for the administrators also to give updates as to the state of enforcement and the companies that have disclosed, so that, I think what we were seeing with the previous legislation is that things were not enforced and history was getting lost. And so with this annual reporting, there's a system whereby there are regular updates so that things aren't getting lost.
I have a, I'm just wondering, because of some of the work we've been doing in Metro Atlanta, could this type of ordinance be expanded to include things like convict leasing, removal of black communities that, there's post-enslavement era, but definitely were harms against our community. So could we use that type of ordinance and expand it to deal with some things that occurred, after our so-called emancipation?
Again, we did not go beyond the enslavement period, but convict leasing was part of enslavement, especially like Norfolk Southern Railroad. We showed that for 35 years during the period of enslavement, they leased our ancestors, and then for another 30 years or more after enslavement, they leased our ancestors. So it can come in if there's a slavery. I think if there's a slavery era component, we can probably bring that in then. Do you agree?
No, I would agree with all that. We had sort of a scope that we were working within, but I don't think that there would be anything that would prevent a particular group from expanding on the scope of coverage, whether that's redlining, unfair lending practices, unfair employment practices. You could certainly expand the scope of disclosure to broader areas.
Yes, no?
Good morning. Could you discuss briefly the interplay between the slavery disclosure ordinance and the procurement process in and of itself? As a former corporation counsel, I'm kind of curious how that would work. Is it just part of the scoring system? Does it affect or impact the award? What's the interplay there? Because there's usually state laws that regulate how municipalities award contracts, and now we have this disclosure ordinance. So I'm just curious how that works.
Yeah, and Nick, I would say that that's an area where we have left things a bit open because, you could obviously understand where you could have a process where you have an entity that has ties to slavery that is disclosed. It makes an offer for redress. Do you give that corporation a benefit in the procurement process, over those who did not exist at the time of slavery, or who don't have a means of offering redress because they didn't commit any atrocities? So I think those are some questions that are still open that I think local groups are going to have to grapple with. And as you said, it's different from state to state and different municipalities. So we didn't go into that level of detail for the model, but that's something that we'd have to address, obviously, as this particular groups start to try to move to adoption.
I just wanted to raise up a point about how to hold corporates accountable. I have been running a reparations working group with one of the largest impact investment shareholder entities around, and actually had a presentation on slavery disclosure as a tool that those who have committed to racial equity and racial justice, which is the foreman of the work of how they've come together, can use that as leverage, right, as they're doing shareholder activism. And so that is, I've introduced it where, but also the other piece of it is there's another conversation I'm having with black folk who are employed in publicly listed companies to please, go buy 1 share, go buy 2 shares so that you can, you're under proxy voting, because these are, like granular ways that you then begin to be able to push and really have your concerns addressed. So there's a lot of excitement within the group to hear how this plays out and if they can use it as part of their toolkit.
Definitely, and I think one of the benefits of what's written into the ordinance is that there will be a website with public disclosure of all of the affidavits. I think we found some interesting things, Stella, you want to talk about. We did a FOIA request for all of the existing Chicago disclosures, and Stella, maybe you can talk about what we received.
Yeah, so we sent out a FOIA request to the city of Chicago to see what affidavits existed, because we did have the concern, is this being enforced? Who is actually submitting those affidavits? And we did receive about 10 responses of companies that have done it over the years. Some were on the screen presented, Wells Fargo. There was some from Harvard University, different entities like that. And what we did review or see from those disclosures were that maybe they will list the names of slaves that they had, but not all the time could they really quantify maybe the exact profit they received over the years. Or generally, some like an institution like Harvard, they couldn't really specify exactly what happened, but they directed us to like their website. A professor somewhere has done some research. So there is information, but to the extent that it's actually detailed to the way that we would like to see it, that probably is still a hole or a gap in the information.
And I just think it was, in terms of the number that were disclosed, it was, I would think, far less than the actual number of actual contractors with the city of Chicago that have ties to slavery. And I think one of the other interesting aspects of the ordinance on the disclosure is that there is a due inquiry requirement. So it's not just to your knowledge. No, you have an affirmative duty to research and to find out and to report back.
Okay, I'll be quick. So a couple of thoughts. One is every jurisdiction should, in a consolidated place that includes everything that relates to this ordinance, should be all of the contracts that the public entity has with any private corporation. So, because a lot of this will be enforced by crowdsourcing, so people can say, wait a minute, I know Westinghouse or whoever their subsidiary or subsequent corporation is, I know they've got a contract, and I think they used to, so there'll be some public accountability. Also, respectfully think about whether you want the DAA to end up as a private entity. I understand why that's a good idea, but it also may deprive you of writ remedies. And I think the earlier question was, what if the DAA gets established and it's totally underfunded and it's completely unable to do all the things that this ordinance requires? If you're in that situation and people in the public want to get this thing enforced, then they've got a handle on it if they can bring a writ and force adequate funding. Oh, and the last thing I just wanted to mention was you might consider automatic debarment if there is no affidavit. So rather than subject to debarment, which I think is the language that I read in the draft that I looked at, it's like, no affidavit, sorry, you're not doing business with us. And there's one more final thing, and that is, yes, there is going to be plenty of just BS, inadequate, yes, we own 2 slaves or whatever, like a really surface level compliance, unless there's some criteria or unless there's a template, or again, unless you're inviting the public, take a look at this. Is this what, because I think there'll be people, as the professor mentioned, the local reparations efforts are going to have an interest in seeing this fully complied with, and you'll have allies who can help you. Thank you so much for this great work. We really appreciate it.
So this section is the section that I really, press the law firm to really prop up, because over the years of dealing with this, there has been no redress element. And so we wanted to make sure that we had redress element, and it took a lot of work to get this down. I mean, we spent a few months, making sure that this was correct. So the redress element, there's the city or municipality shall, and we put that word shall, it's not voluntary, shall establish a fund under the oversight of the administration, and in each particular city or state, that will be determined, as it was just brought up in our last conversation. And this fund shall, again, be used for the purpose included but not limited to providing, and this probably is gonna be altered a little bit because we want to take out some of the specificity, but right now it says providing educational support and support for economic development in the economically depressed areas, especially those subjected to redlining or with a significant portion of private property was seized or otherwise directly impacted in relation to projects conducted under the auspices of the U.S. Department of Housing. So what we try to do here, and what Professor Tillery came out, stressed earlier, is that we have to use language that is non-racial. Is that correct, Lynn?
Well, I think the idea is that in terms of how the dollars are spent, it has to be tied either to the harm, or if it's being used in a way that has a racial classification, that it's narrowly tailored to a compelling governmental interest. And as we've seen with some recent legal cases, that the bar for that seems to have gotten higher. It seems that in terms of recent cases, that you have to be able to show measurable evidence, and you need to have background and findings. So I think, however the ordinance is implemented, at the time, I mean, not that different from Evanston. It was the Evanston ordinance. It was narrowly tailored to the people that were harmed by the practice in housing. So I think similarly, when the money is being spent and when the programming is being designed, there's going to have to be care in how those programs are designed.
For sure. So we also look at how the funds are used and the disclosure of those funds. How there should be guidelines established by each municipality. And in addition to establishing the fund by the city, the contractor has to submit a statement of financial redress. And we found that in Philadelphia, this was a requirement in their slavery disclosure ordinance, that in addition to disclosing, there had to be a statement of financial redress. They may have called it something else, but that was the only municipality that had such a clause in it. And we wanted to make sure that in this model, we know upfront what this particular entity intends to present in the form of redress if they get this particular contract. And that's made public. It may not be enough, and that's something that the community will determine, but having that statement of redress allows them to continue with being looked at as far as being awarded that contract, and so they would have to do that. And then there's monitoring. The city must report out that they receive these statements of financial redress, and if they have been used, how they have been used. And then the next component is administration, enforcement, and severability. And we're going to talk a little bit about the administration component, and then Lynn in the enforcement section, you can just go right into the next section of defending. All right, you and Stella. Okay. So if you can talk about the administration component.
Sure. Very briefly, so the administration section, that's section 6 on one of the last pages, gets to what the commenter over here was saying, which is really putting flesh on the bones of how this will work. So fleshing out the details, what does the disclosure statement look like? Let's create a form for it. Fleshing out the details about how violations will be investigated. And then finally, establishing a schedule for regular public hearings to maintain this infrastructure of accountability and communicating the information out. So that's what the administration section is all about, and that's kind of a supplementary piece of the process that is going to be filled in at the local level.
And then on enforcement, you will see that we've built in some debarment procedures for certain actions. And in the case of what we have in the model, it's currently limited to the current bid, though you might consider whether that would be on a look-forward basis. We thought perhaps that it was better not to affect any existing contracts that are in place, but certainly that's something that you could look at as you examine the issue in your local groups. But essentially, a failure to submit the affidavit would bar you from participation in the current bid process. Any contractor who willfully or negligently submits a false affidavit would be subject to debarment in that current process. And again, you might consider whether that should have a more punitive result than what you see there. There is a process for the agency to determine a deficiency in the affidavit and to give the contractor a right to cure with a failure to do so, also resulting in debarment. In terms of enforcement, one of the things that we thought it would be important to have here is that you have a private right of action, so you don't end up with a situation like we currently have, where we have disclosure ordinances on the books in several jurisdictions, and there's simply been no enforcement because the governmental actors there may not find this to be of importance. So we could have private groups with the ability to bring actions on behalf of the public in the event that the government doesn't.
Sharon, I want to talk about how important that is. Guy, Mount, and Kane was his. Kane still here? I met Guy when he was a graduate student at the University of Chicago. They were doing reparations at the University of Chicago. Through his research, their research, it was 4 graduate students, through their research, they determined that the University of Chicago's land was donated by an enslaver, Stephen Douglas, Stephen Douglas of the Lincoln-Douglas debates, and that he was a notorious enslaver. I mean, the enslavers in Mississippi said how notorious he was, that they needed to get rid of him. That's how bad he was. And one of our initiatives that we were trying to push under the Slavery Disclosure Ordinance was that since this university had ties to enslavement, and they were the chief entity in relationship to the Obama Center, that we could use the Slavery Disclosure Ordinance to stop that whole process of this Obama Center being built. And the electorate didn't want to have nothing to do with that process, enforcing the Slavery Disclosure. Not that we want to stop the Obama Center from being built, but we wanted to use that to make sure that we got disclosure of the university's involvement in enslavement of our ancestors, and we got some redress actually in that process. And if we had the right of private to bring up private enforcement, we could have did that and made that process look a whole lot different than what it looks like today. So that's how important that particular clause is in this language. So with that, I want to just bring you up, Lynn, if you want to present from there, or you and Stella, on how some of the legal challenges defending, because that's a major component. When you attempt to bring this before your municipality, they're going to be asking these questions, as Nick just gave us an example. And this part is very important, so in convincing your electorate to actually implement this legislation.
Well, I would just say that we looked at a few issues in drafting the ordinance. Obviously, equal protection in terms of how the dollars are spent. We looked at issues around bills of attainder and whether or not a mandatory contribution versus a voluntary contribution on the part of the contractor in terms of redress, how that might be interpreted as a bill of attainder, which for the non-lawyers is basically it's a legislative determination of guilt or penalty, or basically imposing a judgment or a remedy without due process. So we thought that might be concerning. And then in light of some of the recent cases that have come up with Students for Fair Admissions, and subsequently with this group, American Alliance for Equal Rights, which is basically the same person driving these lawsuits, but there have been several lawsuits that have come up recently against private actors for having diversity programs. A venture capital fund in Atlanta that makes grants to black women-owned businesses. There's an injunction in place on them proceeding to give those grants. There are several law firms that hire diversity interns, and those programs have been challenged. So it's a much more challenging legal environment on the diversity front at the moment. So we wanted to make sure that we took those considerations in hand as we were drafting. And Stella, if you want to talk a little bit about some of the particulars, go ahead.
Yeah, so with respect to the Equal Protection Clause, that is based on the 14th Amendment, and just generally with that, the goal for any legislation or any program that is being challenged under that amendment, the courts consider whether the action or the program has a compelling interest, and whether that compelling interest is narrowly tailored. And those are the two broad tests that are consistently applied, especially when there are challenges based on race. When we've considered race-based challenges or issues, there is this concern that with a compelling interest, whether it is too generalized. That's something that, as Professor Redwood was talking about the purposes and findings section, that the court has consistently found that it's not enough to just say we want to remediate a past harm, that it can't be generalized. It has to be tied to measurable evidence that this is the reason why this program why we have a compelling interest to go forth with this particular action, with this particular program. And then considering going a little bit further under the narrowly tailored test, the courts also look forward to see, yes, you may have a compelling interest, but is it actually tailored specifically to what you want to be done? And that's usually what the courts try to go through when they're considering, does this pass equal protection challenge? And that's just a general overview. When considering your particular ordinance in your jurisdiction, that's something to keep in mind generally as you're drafting or remodeling the model template.
And just on that point again, to the extent that you have commissions, if you are documenting the historical governmental actions, private actions that occurred in your local jurisdictions, and you can show the impact of those actions and the harms, and you can have empirical evidence of what happened and what the results were, that goes towards proving the compelling interest. So that will be helpful to have in your record.
Yes, and going on to the bill of attainder issues that Lynn mentioned briefly. So generally, the bill of attainder under Article 1, Section 10, Clause 1 of the Constitution, essentially states cannot now punish an entity or individual based off of something that may have been previously legal. So specifically here, at the time slave trade was going on, it was the law of the land at the time. It was fine. So a potential argument could be that by bringing this slavery disclosure ordinance, you're essentially punishing something that was okay at the time. And that is where we have to consider what potential challenges could come up there. Generally, the courts look at whether the law is considered to be punitive, whether it's saw as a punishment. And there are 3 tests that the courts go into. There's a historical, functional, and motivational test. I encourage people to also look at, this is important in how you're drafting, but generally, historically, under the test, the courts look at what are historical forms of punishment. That's usually deprivation of property, that's usually imprisonment, things of that nature. And the Slavery Disclosure Act or ordinance as it stands isn't, by asking them to contribute to a fund, it isn't that kind of historical punishment. But more specifically, I think where the issue may or may not lie would be under the motivational and functional test. The goal of the Bill of Attainder challenge is it shouldn't be a punishment. So under the motivational test, that considers the legislative record with respect to how are people talking about the ordinance. Previously there have been cases that have found that if you talk about it, oh, we're going to make them pay, or, we demand this right now, or, just statements that sound like we are trying to punish them, that would trigger a Bill of Attainder challenge. So it's just an encouragement that how we speak about the law is also very important. Discussing that, narrowly tailoring it to saying that there are harms that we're trying to address, to resolve. It's not that we're trying to punish, corporate actors and those are statements that could raise Bill of Attainder challenges. So we caution, based on the law and case law, that framing the ordinance as a punishment or a way to get back at corporate actors would be likely dangerous territory. And then lastly, with the Civil Rights Act of 1866, with the Harvard case that was recently decided in June of this year, and recent litigation, specifically with the Fearless Fund case in Atlanta, the argument there was that under the Civil Rights Act of 1866 is that, there's an interference on the right to make a contract. And that claim in that case is saying that, by racially discriminating or providing funds exclusively to the benefit of one group, you're interfering on my right to contract or my ability to apply to the fund. And that's where we are concerned of potential pushback given the current legal climate. In my personal research, I've come across at least one case in the Fourth Circuit where race-based scholarships, I think it was the University of Maryland, that was found unconstitutional, and that was scholarships awarded only to black students. So if that seems to be the general trend, or where maybe, depending how the case in Fearless Fund is decided, we have to look out for how funds geared towards a specific group, how that could potentially be challenged. So with that, that's some of our research, some of our observations in how to potentially be aware of potential challenges that might arise to the Slavery Disclosure Ordinance.
So I know that was a lot of legal, legal commentary. In that regards, we're going to actually, Lynn, could you talk about the legal toolkit that we'll be formulating so that it will be helpful for all of the municipalities to discuss
Right.
with their.
Yeah, so we will be putting together a toolkit to go along with the ordinance that will omit the legalese, but basically provide you some best practices in how to proceed with putting together and implementing the ordinance in your local jurisdictions, some of the gaps that are in the current law that will need to be addressed as you move towards implementation, and hopefully some of the avoiding some of the pitfalls that might bring on a legal challenge to the extent that those can be avoided.
We have time for about 3 questions, and we're going to do the last section really quickly, and that's implementing the ordinance. I see you, Sister Bree.
I'm gonna be quick. I know it's lunch. Hi, I'm Brianna Moore. I'm the co-chair of the Philadelphia Reparations Task Force and in Cobra PHL chapter. So in 2005, 2 of our council members and Brother Ari Meredazan passed the Slavery Disclosure Ordinance. They actually went back and amended it to include a require reparations financial statement from the banks who are doing business with the city of Philadelphia. Since 2005, it has not been implemented. Some of the banks are saying that some of their community reinvestment goals count as reparations. We know that's not true. We also have seen evidence of banks literally giving statements to the city saying that they will not make a reparation financial statement, that they're choosing to opt out, which is not a legal option. So I just want to say that the city of Brotherly Love invites you, everybody on the panel, anybody in the room who wants to help us enforce the slavery disclosure law and reparation financial statement to come. Thank you.